From the Library of Congress in Washington, D.C.
Okay, great. This is the fifth session of the day. As the board tells me, this is the intersection of moral rights and other laws. As you heard earlier today, the U.S. adopted the patchwork model to providing moral rights upon joining the Berne Convention. In the U.S., our mechanisms for recognizing moral rights come not just from the Copyright Act itself, but also from a variety of other federal and state laws, as well as supplementation from private ordering. The patchwork, though, isn't just the source of moral rights, it's also the scope of the rights we have. And that's what we're going to discuss on this panel. Not just where those rights come from, but how they're defined and how their definition is shaped by other laws. We'll look at the interactions and instantiations within the Copyright Act itself, such as the Fair Use Doctrine and VARA, the boundaries of VARA, at free speech considerations that exist outside of fair use in the traditional contour of copyright law, and at business and contractual arrangements that guarantee proxies for moral rights, such as you heard earlier, the Creative Commons created by license. We have some amazing panelists here to discuss these issues. On my left is Professor Sonia Boneau of Georgetown University Law Center. To her left is Paul Allen. Did we say earlier it was Levy? Yeah, not Levy. Paul Allen Levy, an attorney with the Public Citizen Litigation Group. To his left is Eugene Mopsick, a retired professional photographer and a longtime advocate for visual artists. Then Nancy Wolf, a partner at the IP, Media, and Entertainment law firm Cowen Debates. And on the far end is Kate Spellman, who is here from Seattle, where she's a shareholder at the law firm Lane Powell. So I'm going to turn this over to the panelists for brief remarks to discuss various aspects of these intersections. And then we'll have a number of questions to discuss among ourselves. And then at the end, as you've seen, we'll have about 5 minutes, hopefully, for audience questions. So, Sonia?
Okay, well, I hate to bring up VARA again, but it is one of the few moral rights legislative acts that we have. And I just wanted to talk about an intersection from a policy standpoint of VARA's place in the Copyright Act and it's the multiplicitous goals that it, under which it was enacted. And even though it's this tiny, tiny, narrowly circumscribed statute, it purported to do a lot. A lot of the legislative history talked about different things. One was a sense that copyright law doesn't help the visual artist who produces unique objects. Everyone else works on a system of, number of copies sold, whereas for the visual artist, you sell, it's over. The other was what you can think of as the true moral rights perspective, where it's about the individual's connection with their work, although that, to the extent that's what it's supposed to do, there was really no reason to limit it to visual artists. But again, that's part of it. You see that there's a lot of flowery rhetoric, romantic artist type rhetoric whenever courts talk about it, regardless of whether they are actually thinking that's important. And then there was the cultural preservation side to it, which is what I'm going to focus on. As Peter, you discussed earlier, that is the VARA's right against complete destruction of a work of recognized stature is actually the one aspect of VARA that is not required by Berne. So the U.S., despite its 100 years of resistance to Berne, went ahead and enacted something that goes a little bit beyond what was required, but not beyond in a moral rights way. I think it was part of their idea that this could benefit the public because it assumes that the artist's interest, the artist who is enforcing this right, is directly aligned with the public interest. So art preservation's good, we can get moral rights and we can also serve the public interest by saving great art. The problem is, within the Copyright Act, copyright law is based on a progress model in which, as I'm sure you all know, the author gets a temporary monopoly on their work so that they can profit from the number of copies sold, and then that's the incentive for creativity, and then it goes away and the public gets access to the work. Whereas the preservation idea is a completely different notion of, it preserves. It rewards the status quo, and it's animated by an artist when someone wants to destroy their work. And I'm only talking about the destruction provision. So you've got a very different dynamic set up. And I think that's partly why it hasn't worked well. And these combinations and intersections become even more problematic when you look at VERA, the fact that that's the main provision that it's invoked. I mean, very little of it, the case law is attribution, because the circumscribed set of artifacts, of unique objects, is just, it's limited to that kind of production and reproduction.
Thank you, Sonia.
That's the hook.
Paul, you want to jump in and
Sure.
talk about
Okay,
free
so
speech?
it's awfully hard to come out against moral rights. The catchphrase sounds so good. And there are certainly compelling stories told about abuses directed at works by certain offbeat individuals who are authors. But if moral rights are legislated, they'll be enjoyed equally by the mainstream commercial titans. From a copyleft perspective, which is mine, I worry about the impact of legislating new rights on the public domain and more broadly on what might be described as fair uses and downstream uses. Because even if the newly adopted moral rights have fair use exceptions, you worry about the transaction costs of having to defend lawsuits in which fair use rights or First Amendment rights are raised as a defense, not to speak of the intimidating impact of demand letters. To the extent that the moral rights debate really represents a struggle between individual authors and the what might be called the corporate copyright exploiting industries, my sympathies are certainly with the individuals, but it's hard to see moral rights being legislated that give rights only against those exploiters. And moreover, it seems to me that advocates of moral rights for individual creators want to have it both ways. They want to make it easy to make money from expression, using the incentives that copyright law fosters by licensing works through a system that facilitates the use for monetary rewards and taking advantage of the ever-increasing remedies that are available to copyright owners, the ridiculous extension of copyrighted terms whenever Disney rights are about to expire, the terrifying levels of statutory damages, advocacy of criminal enforcement programs by federal prosecutors so that rights owners don't have to have the bother of enforcing for themselves, and of course, ready awards of attorney fees. At the same time, some creators want to use moral rights as a club to stop downstream uses that they don't like, even though they could have prevented many of those uses through licensing, making the kinds of choices that Melvin talked about, but that most creators don't want to insert into their contracts, either because it would make their works much less marketable or because they lack the economic clout to enforce them or to insist on them. So ultimately, despite my sympathies, it seems to me that before we give new rights to creators, we ought to think about cutting back on the rights that they already have. Rather than talking about moral rights as a bundle, moreover, we ought to be thinking about specific moral rights. And it seems to me that proponents need to justify the need for a particular moral right to the extent that, and this goes to the question that I asked Jane at the end of her talk. I mean, most of what she said about the right to attribution was, well, we agreed to it. And there was a long answer about why we agreed to it, and we can debate whether we agreed to and exactly what we did agree to. At the very tail end of her answer, we heard something about the incentive to create. And so what I want to know is, do we not have sufficient creation? Do we need to have more rights, moral rights, in order to create an incentive to create? We also talked about the interests of consumers, but what evidence is there that consumers care about Attribution. Yes, I mean, in trademark law, the reason why attribution rights are important is because in certain circumstances, consumers care about source. And when you're in a circumstance where the consumers don't care about source, you have relatively little trademark rights. So what's the evidence that we need a right of attribution to serve real interests of consumers who care about source?
So Paul talked about negotiations and licensing agreements. That sets up nicely. Gene, you want to talk about how creators guarantee themselves at least attribution rights, sometimes integrity rights through guild agreements, contracts, and how it's maybe a poor fit for some types of creators?
Well, I'm going to start out, I have to make an observation first. It's a rather strange irony that here we are at an event about authors' attribution and integrity, and only one of the images in the program has an actual credit for a creator. We'll go on from there. And I'm going to make some general comments, and then I'll actually make some comments that are on topic.
To be fair, I think some of the credits are actually at the end of the bios.
All right. It appears to me that moral rights, for all practical purposes, are not on the radar of visual artists and photographers. It's not something that they think about in negotiations. They have enough trouble trying to figure out whether their work is published versus unpublished, and moral rights just don't exist for all practical purposes. And under VARA, commercial artists are excluded from any real protection. I would say that VARA and Byrne are both examples of an analog solution to what's now become a digital problem. The works that are protected by VARA are in fact the works that need the least amount of protection today, and the commercial works are much more easily separated from their identifying information than the limited numbers of works of fine art. The preservation of identifying information, such as a rights holder, contact information, and licensing history, needs to be easily associated and maintained with images. Ultimately, its attribution is the holy grail for photographers. Without that, everything really falls apart. There's no end, there's no means to get to creating an ongoing income stream from works. While it's trade practice for editorial work to customarily have a creator credit, the truth of the matter is that it's very difficult to enforce. And as Alan pointed out, yeah, you know, the contracts are there, but and the terms are there, but the enforcement is the issue. And in some cases, it's not enforcement, it's just the lack of having any leverage in negotiating. And frequently when a photographer goes to a publisher, be it for textbook or consumer publication, the contracts they're handed, they're told, take it or leave it. This is the contract. You don't like it, you don't work, you can go somewhere else. And unless you happen to be one of those very rare photographers, like an Annie Leibovitz or you know, one of the top of the food chain, you're out of luck. You don't have any leverage. It's move on, and you either accept those terms or not. Another example, I had a discussion with Yoko at lunch. In Getty Images contracts, they generally call for a credit that reads the photographer's name, Getty Images. If you watch CNN or almost any other television media, and you look for the credit for images that appear, it's almost always simply Getty Images without the photographer's name. And why that happens, can be any number of reasons. It's either it's too difficult for the station, or they can't follow it, or it's simply that Getty doesn't want to enforce that portion of the agreement.
Thanks, Gene. Nancy, do you want to jump in there?
All right, well, great. I'm here today with my hat for representing a trade association, Digital Media Licensing Association, which is the trade association of stock photo libraries. And We had Yoko Miyasha here, who is a leading member, so now I don't need to explain what we do. That's very helpful. So, it's good to follow up with Jean. Yes, there's lots of trade practices, and in print editorial, you generally always got the credit, the photographer name, and then the source, because that's the payment, and that was fairly standard. Digital revolution has made it so there's more images being used ever, yet unfortunately, as even Yoko mentioned, often many of them are just because someone has chosen to right-click. And it's interesting because I do a lot of education and copyright education as part of my role. And most people are amazed that there really is no attribution. And yes, obviously, if we're in the business of licensing, none of these works are subject to any kind of moral rights. But I think attribution goes well beyond moral rights. And if you're going to look at a world where images can be licensed and has a future with technology, it's going to be very important that there is attribution, and it exists in the form of a persistent identifier that can live with an image, and that information can be always attainable. Metadata, unfortunately, is not robust. It gets stripped. Half the software purposely strips it because the internet wants to have small files, and that means a lot of information gets lost. Orphan works is a bigger problem with visual images than anything else because they're orphaned from birth. It isn't as if, that photo libraries and photographers want the works out there without information. It's just that the way they get published online, that seems to happen. The industry looked at this, and that for the last, probably since the Orphan Works Act in was around 2006 through 2008, has started to consider technology options, which would include image registries. As Yoko mentioned, there's already reverse image search. But to really make that happen, there needs to be enforcement, whether it's through what the Copyright Office could possibly do through CMI, that information can stay with the image and be there. And even I think if we're looking at the other laws, I think because image licensing had been one-to-one and perhaps maybe overwhelming and seemed to be too difficult to find ownership, that unfortunately laws in other areas have broadened. For example, it seems like fair use, particularly with art attribution, expanded to make it easier to use images versus other works. And then if you look at image search, which a number of years ago, you do an image search, you get a little thumbnail, and it would drive you to the source. So you could actually go and have an image license. Now, if you look at image search, you get a beautiful, large display of an image. Because the money in the internet now is keeping you sticky on a page. That's where the advertisings are. So there's no incentive to drive you back to the original creator. You can see a small line that says, do you want to just look at the image or do you want to see the website? Well, you have the image, that's all you need. So you're not driven back to the website. So I think if there was a way to have persistent identifiers that stuck, and you can then introduce licensing models where it would be easier to license, and maybe you wouldn't have such the overexpansion of fair use like in Google's books, because it's easier not to get permission and not to have some kind of licensing mechanism, and you won't have technologies being built for the narrow takedown notices.
Great, thank you. Kate?
My part in the choir here is the intersection of moral rights and real estate, physical property. I was a student of VARA. I thought VARA was something I understood. I was also a regular volunteer at California Lawyers for the Arts. And if you can imagine, on a foggy February of 1993, I alone arrived as the lawyer volunteer in a very abandoned pier warehouse where we welcomed anyone to come and ask copyright questions. And you can imagine that I was a little terrified when the door opened and in walked three giants, really looking pretty rough, with tattoos up their neck, and I had never seen that before. And I thought, the end is near, but indeed they walked over and they held up magazines and travel guides to tell me that they were indignant that their murals, which they had carefully painted on Balmy Alley in San Francisco's Mission District, had been reproduced without permission, and most of all, without payment, to be cover articles and to be indeed covers of some of the most famous travel magazines, travel guides for the city of San Francisco. And they were indignant in the sense that they didn't think it was fair. And I had the pleasure of telling them that indeed they were well within something called the Visual Artists' Rights Act, the VARA, and we then began working together. Scott Turow had the experience of his publisher saying, oh, that doesn't apply to you. I had a very similar experience in that when I contacted the relevant publishers in 1993, their first answer was, what? What's VARA? And their second answer was, when I showed them what it was I was at issue, they said, that's not art, that's vandalism. That's not art, that's graffiti. That's not art, I don't have to talk to you, goodbye. And I had to then explain that the people of Balmy Alley had made their alley, the walls of their alley, and many of you, I'm sure, have been to Balmy Alley and seen how fantastic these colorful, vibrant, magnificent murals are, that indeed that there was consent and the real estate people were all in cahoots with this, and we pursued what was several very, very productive settlements for the community that had painted these, excuse me. Fast forward to 2013, and I get a call from people in Detroit who tell me they have a mural issue, and by now I think I've pretty much got the rhythm of murals. I think I've figured out VARA and murals, and I got this square dance, and I kind of know the do-si-do, and I think I'm doing all right. At which point we learned that what happened, the facts are so spectacular, I have to share them with you. Dan Gilbert, a Cleveland fellow who owns the Cleveland Cavaliers and is also revitalizing Detroit. He has, you may know, has brought lots of street artists to come to Detroit, and in one instance he brought 6 famous street artists to come to Detroit to paint for each of the parking levels of the new parking building he had. He brought new fabulous street artists, including Banksy, to Detroit to take a floor so you'd always remember where you parked your car. Well, Banksy finished his day of work for Dan Gilbert, who was very generous as a patron in commissioning this, and they partied all night, and it ended up that he ended up in Hamtramck, a little town inside of the town of Detroit, and at the Packard, the old Packard automotive plant, which, as many of you know, has been abandoned, literally abandoned, for 26 years. Abandoned to the point that no one's paid taxes, no one's done anything, it's just no man's land. And Banksy and his team stenciled a giant of one of his favorite stencils on it, and a gallery owner in Detroit noticed this happening, sent an armed guard down after Banksy and his team was done. About dawn, they sent down armed guards until a 16-wheeler could be arranged to come down, and they cut the Banksy stencil out of the wall of this building, put it on the 16-wheeler, and then welded a frame around it, enjoyed it for a period of time, and then put it up for sale. The auction was going forward, all was going well, until the owner of the Packard plant thought, hey, that's my plant, you took my wall. And so they raised their hands and said, you can't do that, that's our wall. And it will amuse you to know that the judge in the city and county of Detroit said, yes, it is your wall, and you haven't paid any taxes for 26 years. If you would like standing to bring this dispute in Detroit, you will need to pay back taxes, penalties, and interest, and that comes to X, which was almost $750,000. And he quickly said, oh, I guess I don't have a problem. and the work then was sold at auction by the gallery company for about $325,000, this big piece. And when Banksy was contacted, he was like, I had a good time. I knew what I was doing. Okay, by me.
So, Kate,
So my intersection is that of an area of law that you don't think of colliding with VARA. Excuse me.
well, yeah, no, so that this is a good way for us to sort of close the book on the VARA discussion, at least for our panel. And that is that VARA tries to strike a balance between property rights and moral rights. So here we're really talking about personality rights. You can think of property versus personality. But pretty quickly after VARA was enacted, we had the Helmsley Spear case, which, you know, the court says, well, these weren't absolute rights for creators, and we have to assume that traditional property right values have been left in place. And I think in the 5 Points case, saw something similar with this in recent years. So I'm wondering the balance that VARA strikes between property and personality rights, and who are the winners and losers in that balance?
Well, I would say it's pretty obvious that real estate wins over VARA in most situations. It just seems that no matter what, the courts seem to favor property owners. I remember when I was baby lawyer and first going to federal court, I loved this arch down in New York, this magnificent arch, and no one else seemed to like it but me, so it was taken down.
Not recognized, work of recognized stature?
Wasn't a work of recognized stature. It was fabulous, but yeah. There's so many ways to wiggle out of VARA, and artists can waive it, so it seems that the property owners and the value of their property, and if it's inconvenient to have the art in the lobby or in the front, the property owners win.
Let's assume someone owns it.
Yeah, yes.
Other than Banksy. I wanted Banksy.
Okay.
Can I just add
Yeah,
a quick point?
absolutely.
Which is that it's not surprising because American law is based on property rights. And so you have that dissonance, whereas attribution, as has been obvious throughout the day, it's a powerful social norm that most people do believe is the right thing to do. So just as a moving forward thing, I think attribution has a lot more grounding, at least in our.
So that, good segue. Jane Ginsburg in her keynote talked about maybe attribution should be, in some of these cases, sort of part of the first factor in fair use. And that courts are looking at, was the work attributed? And so we get to the issue of fair use and attribution and appropriation art. Should Richard Prince have to, carry you somewhere on that photograph or photographs? Can appropriation artists, can they still do their art and be expected to attribute the source of the work?
Yeah, you would think that at the least when Richard Prince took Jim Krantz's Marlboro Man, one of these iconic photographs, and basically performed copy work on it, enlarged it, it was then part of a significant exhibition at the Whitney, used on a poster, I think, to advertise the show at the Whitney, sold for substantial amounts of money, and he makes no identification at all of the underlying work? Nothing? I mean, not a handshake, not a, and I contacted Jim Krantz because he was a member of our association, spoke with him. He unfortunately, he did not own the rights to the image because he'd shot for a tobacco company who insisted on work for hire. So he didn't have the rights to the work, and the tobacco company really didn't care what Prince did with it, as long as they spelled Marlboro correctly. So, there was no issue there, so Prince couldn't bring any action. Krantz couldn't bring any action, but you would think there would at least be some acknowledgement of the underlying work at the minimum.
That goes to, so when Paul was talking, he talked about how he didn't really see how this would benefit authors, and I think that raises a question of whether or not the moral rights would be transferable. If they're transferable, I think you run into maybe the same sort of problem we had with the reversion right before the 76 Act. If they're not transferable, maybe it looks more like but if they are waivable, so maybe you don't get the termination value. But the question there that sort of is risen by what Gene was saying is if the owner of the copyright doesn't have the interest in making sure the work is attributed to who did it, who can step in if not the artist?
No.
Go ahead.
You don't care.
This goes to the question of whose interests are served by the moral rights. If they're freely waivable, then all you're doing, you're not providing any real right against the people whose use is based on permission, traditional copyright exploiting industries. You're only getting rights against downstream users. And so then the question is the benefit that's secured by creating the right worth the imposition on the later users? And I think you need to you have to make an argument for why the benefit is needed.
I think
in
Nancy
order
has
to
the
get-
argument.
What?
Well, I'm thinking you're putting it in a category where there's, again, winners and losers and us and them. But I think the impetus for moral right, it's a personal right that doesn't attach to a personal work, but it's a right of an artist to always say, you know, that's my work. It belongs to me. I mean, I still remember doing contracts where an illustrator worked for like a large animation company, and they were told they weren't even allowed to put the work in their portfolio. And I said, you know, you have a right to say you did that. But if there was a persistent attribution, you wouldn't worry about the downstream users. And that right of the artist to always feel attached to say, you know, I created it. That, I mean, when an artist creates a piece of work, and I tried Art Students League, so I know the difference between what I can do and my clients. It's a part of them. They are so attached. I mean, I have clients that it's almost like they're children. I had one of the artists from when Prince did the Instagram ones who contacted me, and his work was shown on art galleries as well. So I think if you look at benefit, I think the benefit to the artist is a benefit to the public as well. It isn't that there's a sharp divide that somehow if you benefit an artist, you've hurt the public, because we're all artists. In this community of internet, we're users, we're creators, we're a little bit of both. And I think making those bright lines, we miss having a dialogue.
I think that's great, but you know, when you create a right that's enforceable in the courts, that means you have the potential for litigation against an individual who doesn't have regular contact with lawyers, for whom if they have to spend $15,000, $20,000 to defend themselves for something they put on their Facebook page, they've already lost. So if you, I come back to,
But most artists have never gone to court. They can't. The only ones who go to court is Prince. He sells his work for $1 million. I mean, what the artists are really looking for now is the Copyright Small Claims Court, where something could be resolved for the actual value of a license, where it wouldn't be so burdensome.
The rights holders are primarily disenfranchised right now. They can't bring a $150,000, $200,000 federal copyright case. You know, the average photographer is just unable to do
you're
that.
saying the rights holder or the creator?
Well, for me, most of my photographer friends are still the rights holder and the creator.
So if I can turn the direction a little to where contract law seems to be doing more work, there are, well, there's at least two areas. One is, and we can start with, well, there's the director who can retain final cut authority because they have the bargaining position, or you have the editor who gets credited because it's part of the guild agreements. The question here isn't what is the source of the right, but how important are those rights as provided for by contracts and guild agreements? How important are they to authors?
Well, I mean, I'll speak as a creator and author, and not as an advocate. That from my standpoint, and what we heard earlier from creators, I think, you know, creators do want to be recognized for the fruits of their labor, and they want to see their name, you know, associated with their good works, and it's just part of the creative process, I think.
I'll speak for the film lawyers in my office who I get to do all their fair use reviews, but I can tell you that credit is significant, and I think it's one of those terms that it's importantly negotiated, and where it is, and the placement and the size, it matters because that's your career, that's your portfolio. You get to make your next movie based on the success of the one before, and again, having the acknowledgement for the fruit of your labor is I think, a significant moral attribute, but also financial ends up being.
Yeah.
Yeah, let me just say, so I don't know how many of you watch television in December, you know, at the end of the year. I always seem to have the TV on when I think it's the Today Show, they do this year in photos in the morning, and they show 10, 15 of what they, you know, say are the most fabulous images from the past year. Invariably, those images have no attribution. They don't tell you who the photographer was who took these fabulous images. And as my mother would say, they all sit there and kvel and this and that. Oh, what a beautiful photograph, how great it is, this and that. But they don't tell you who took the picture. I mean, it's incredible. I mean, how hard is that?
Well, what role then, to add to that question, does private ordering then play for these authors? I mean, do they look at copyright law and say, copyright law doesn't have an attribution right, but I know I can get it from contract? Or they just not even think in terms of copyright law when it comes to attribution or placement, and they're really thinking in terms of deals?
Well, I think it's bargaining power, and yeah, if you're at a certain level, you can require attribution. I mean, if we were talking just about photography, typically if it's something in advertising, it's never been the norm, and even I think Annie Leibovitz won't get credit in an ad. She'll get it for the cover of a Condé Nast magazine, but not for an ad.
But I would say it's an enfranchisement tool. I would say that particularly for those who work on murals, that they get it and
Yeah.
they really understand it. And it became a civics class now in the Mission District of San Francisco. It's actually in their curriculum. These kids really care about it. They think it's just, so they're really enfranchised because of it.
So that's really interesting because in '96, this office did a study looking at VARA, the first, I think, 5 years of it. And one of the things I remember from the study was that something like half of visual artists didn't know that your rights could be waived, and something like a third or another half had said that when they had blanched at the waiver provision, it killed the whole deal. Has the climate then changed for visual artists? Do they feel like they have more bargaining power now to insist on certain terms, or are we same place?
I'd say they have less leverage now than they've ever had in the marketplace, because the publishers are scrambling for every dollar they can get out of the proposition, and the rights package that photographers have been asked to sign has significantly expanded now, because you're asked to give rights not only, I mean, it used to be 20, 30 years ago, it was a North American one-time first publication print. Now it's, on any platform now known or envisioned, what's the term they use? Or yeah,
Later created.
Right, later created, it's all forward thinking and.
Throughout the universe.
Right, throughout the universe, and you've got, it leaves the creator with nothing. It leaves you with no ancillary rights.
Kate, is the same true for muralists and sculptors?
No, what I'm seeing is there's a break here that
Yeah.
seems pretty clear, that those people who are dealing with photography, which is digital ab initio, it's a much more volatile, problematic area than what people are doing when they are, as a community group, painting on walls, or as an individual painting on walls, or perhaps in sculpture as well. But I'm seeing a schism, and I'm wondering what the other speakers think about this. Nancy?
Well, I think with sculpture, in fact, I was helping a UK lawyer look at a commission for a large sculpture agreement for a real property owner in Philadelphia. And I was so surprised. I didn't see any moral rights clause or any waiver, because I think a real estate lawyer did that contract and had no idea, just could tell the way it's written. But I think if you're doing something for a large museum, they've read all the cases that deal with moral rights, and they know how to write contracts that protects the interest if something needs to be moved or it's not finished or altered.
MoCA did not have a contract with Buchel.
Oh.
That was,
Yeah,
the judge was incredulous.
Right. So I think they learned from the Mass MoCA that museums need contracts, and they learned that they should ask for waiver. And I think if you don't agree, you might not get a commission.
Yeah. So it's not just the type of artist, but also the type of contracting party.
Right.
Where the schisms are. I think our last question that I'll ask before we open up to the audience is that we typically think of, and it probably because Byrne requires attribution and integrity rights, but there are other moral rights. And I think there's an analog maybe in the digital age to the right of withdrawal, which is something like a right to opt out or a right to insist on non-use. The direction, though, the fair use doctrine has moved, and the Google Book search denial of cert today, I think, really hammers this home, that this is a question for authors is, how do I opt out of these systems? Does that seem like that should be part of a moral rights suite? Is that something that authors are thinking of or wish they could think of?
A right to be forgotten.
No, I don't want to use that term because it's not. It's not, right? It's not, this isn't like fully removing your work from the marketplace, but it's a right to say, I don't want to be part of that new distribution system.
Well, I mean, the problem, as Yoko pointed out, a company like Getty is able to put certain limitations on works, and the most common ones have to do with liquor and smoking. But beyond that, once the work is out there and the identifying information is no longer with it, you have no control. And that's what, I've listened to people talk about contracts all day. Well, yeah, contracts are great, but ultimately it means you've got to be able to control the distribution of the work.
And I mean, that's a clear threshold problem, but assume that wasn't an issue.
Oh.
Just assume in a
I-
utopian universe that you always knew where your work ended up, and you knew if somebody was using it.
Go ahead.
Yeah, well, one thing, I see one sort of bump in the road, which is, I think once something is considered or would be considered a fair use, then it's considered an authorized use, and I don't know, there might be a conflict between the right to have a work removed, particularly if someone has added a lot of substantial creativity to it, to the new work. I think that might be a difficult. If it was the work unaltered, it's always going to be cached somewhere. I think in that way you can compare it a little bit to the right to be forgotten in Europe, where the original article will never disappear, but the links to it go down. I think, it's very hard to wipe clean the
But
web.
it's awfully hard to think of enforcing anything like the right to be forgotten in a country that has a First Amendment.
Well,
And I think that's the problem with the right to be withdrawn to the extent that it's a fair use.
Yeah.
Or maybe you don't have a fair use provision, but then you're just going to be litigating the First Amendment issue when you're asking a court to order the removal of something.
Yeah. I guess we have time for one last follow-up to that. So Paul, just to follow up on your First Amendment discussion, a lot of the patchwork comes from outside of copyright law, where the fair use doctrine doesn't necessarily or doesn't apply. What role there does the First Amendment do?
Well, you apply, certainly in the right of publicity area, you end up applying the right of fair use by analogy. And to the extent that you don't have the right of fair use, or even backing up what there is, the First Amendment has very broad application in right of publicity cases, certainly outside the purely commercial exploitation situations. But there is a First Amendment right to engage in commercial speech. And then there's the distinction between having it in an advertisement or having it in a product that's sold, and yet then you have protection for what's considered to be non-commercial speech in a commercially sold work, like the advertisement in the New York Times, for which the New York Times was held not liable. In New York Times v. Sullivan, this was treated as non-commercial speech, even though it was an ad. So the First Amendment has ample role to play in these sorts of situations.
Although I think that's why Michael Jordan was successful in one of his, he had several lawsuits, and because commercial speech gets less protection under the First Amendment.
Right.
That's a big question of, is it commercial speech or not? And the courts get into this classification system where they have to say what a given work is. Is it art? Is it advertising?
Right.
Great. Well, I think now we're going to open it up to the floor. So if you have questions, just give me a little hand and I can tell Donald or someone else to bring you a mic. Yeah, Michael Wolf.
Thanks very much for that. I greatly enjoyed the panel. I'm going to preface this by saying that my organization, Authors Alliance, is in many ways also sympathetic to copyleft ideas, but we also endorse the idea of an attribution right. But all the same, I do find Paul's earlier point an important one, and I think Danielle made the point before him regarding the real source of attribution controversies being from downstream licensed uses. So I wanted to sharpen that a little bit for the panel and see if we can't all address it and find out whether there's something else there. But is there, assuming a waivable right, is there a practical value for authors from a waivable attribution right if it's only downstream license uses that are the problem? And if it's not, and if there's more than downstream license uses that are the problem, let's say Richard Prince, for example, although I think he is the exception rather than the rule, where will there be an instance of an attribution controversy that is not also an infringement of the rights of copyright and remediable from that avenue?
Any takers?
I mean, certainly to the extent, particularly when you're dealing outside the range of form contracts with huge commercial enterprises with which a creator is dealing, a writings requirement and an explicit writings requirement at least provides a point of discussion and sort of conscious giving up or conscious taking. And I think requirements of clear and unmistakable waiver, for example, play a large role in many areas of law, and I think they're valuable.
Just one brief comment. You commented on the difference between, or the ability to remedy through, if something were a copyright infringement, that you can in fact bring a case. And I go back to my earlier comment that by and large, that's not a remedy. At least not a remedy for a photographer who makes $30,000 to $50,000 a year, who most probably didn't register his work to begin with. There's no remedy for those myriad of uses that are being made of his work.
That's a fair point from a procedural standpoint, but would the moral right be more accessible to the author in that instance? I suppose would be the follow-up.
Well, I guess it depends what you mean by accessible. If an individual author has to try to locate all these downstream users, most of the problem is it's the impossibility of it. They could be anywhere in the world. How do you go after them? I mean, I think that's been a lot of the problem with anything that goes viral. I mean, if you take something so you've made another copy rather than do what like Getty Images does and allow you to embed where you go back to the source, it's really an impossibility to, whether it's under moral rights or copyright infringement, really to enforce most of those downstream uses.
And I'll just say about, if in fact the moral right is waivable, I would venture to guess that when it comes down to a negotiation with a photographer who's faced with what I call the 30-day horizon, which is the next billing cycle, and he's got to pay his bills and worried about rent and everything else, he's going to give up that right. No question.
But if the law gets too complicated, then it can have the chilling effect on, for lack of a better word, amateur users who are using the web just like the big commercial players. And so we have to think about how accessible the legislation would be to use.
Jane?
Yeah, we're not chasing the amateurs.
If
Mickey?
it's not inappropriate, I'd like to venture an answer to the question, which is
Yeah.
one big difference is between an infringement action and a moral rights action is if the author doesn't have the economic rights anymore, the author doesn't have an infringement action, but the author could still have a moral rights action.
Good point.
And I'd like to make another suggestion regarding downstream uses, which may require legislation, but I have to think about if you could do it without legislation, which is, as Nancy says, nobody wants to go after downstream users. But what about the platforms? Could there be a 512 type claim based on attribution? So in other words, if there's no attribution on the content that has been placed on the platform, that would be the basis to either have it taken down or attribution added. So that might be a way of rendering enforceable an attribution right which is distinct from the economic right.
And if there were persistent identifiers that readily identified the owner of a work, then maybe the issue of all this red flag knowledge would raise its head again. I mean, if you knew what was going uploaded on your platform, was not by the same name as who was loading.
It would be interesting to
Interesting, yeah.
construct all of this. I'd also point out, however, that at least under CMI, it's the right holder, right? And again, the right holder is not necessarily the author. So you would have to have a basis for the author to protect
Correct.
that robust information.
Plus does that.
Yeah, the plus system is trying to do that right now.
It recognizes both the rights holder and the creator and licensees.
Right, but I mean, in addition to the technical basis, the legal basis.
Mickey, you got the mic?
Yeah, just, we've been talking about attribution rights versus economic rights, but what we're seeing, especially with photography, is people see your name and then they contact you and say, well, we don't have a budget, but we'll give you a credit. You want to talk about that kind of reverse problem?
Yeah, that's, the attribution on the one level helps build the brand. And so it, helps the photographer become identified. At the same time, it certainly doesn't pay the bills directly. And there are, as Mickey points out, numerous cases. Many years ago, I did photographs of the lighted Ben Franklin Bridge in Philadelphia, and the architect calls me up, and he had the opportunity to license these images to use for his purposes. And when he found, I gave him the fees for it, and he didn't want to pay. He didn't want to do anything. Well, then 2 years later, I get a call from AIA. They're giving this man some Life Achievement Award, and they want to use my photographs as part of the presentation, thanking him. And so I said, he had the opportunity to license these images, and he turned it down. I said, what do you have in your budget to use this image in your presentation? And they said, well, we don't have any money, but we'll give you a credit. And I said to them, look, I have to tell you, I make my money through licensing images and through creating photography, and quite frankly, I'm not an architectural photographer. I did these images of the bridge just because it was something that I happened to like, so I did them on spec and then sold them to a magazine, and I said, that credit has no value to me. I said, I'm sorry, we can't eat the portfolio piece, doesn't work.
I got time for one more question, I think. Yeah.
I just wondered, given how the CMI information is stripped from images, do we really want to put an affirmative duty on fair users to be able to have to then find out who the author is in order to give them attribution?
So,
Certainly from a litigation standpoint, as somebody who represents sort of individuals, I would worry about that. Also wondering, what are the remedies for having failed to do that? If it's simply injunctive, that's one thing. If it's damages and attorney fees, it's very different. And yet, if you don't have the monetary remedies, what's the disincentive to do it?
if I could ask a follow-up to sort of just sharpen that question, what, though, is the real harm to a user in if they're going to use somebody else's photo or someone else's music or someone else's whatever, that they either use something that they know they can identify the author and credit that author, or they don't use the work? Like, well, I guess I don't. Well,
So I'm putting up a photograph on my Facebook. Of course, Facebook requires me to sort of verify, but right, that I've got the authority. But I think for the small user, knowing actually how to stick that stuff in,
sure.
it's difficult.
But that could be the reasonableness requirement, right? And similar
Right.
to
Right.
with broadcast, where it's not reasonable to include the attribution. Maybe there it's for the user where it wouldn't make sense, or there's nowhere to put it or whatnot.
There is a free website called TinEye, and you can put the URL with an image in, and it'll find you all the matches.
Yeah.
You may not get the one that actually is the owner, but it is really fast and really easy. So I think this question now, it might not be reasonable, but I can see a future where this could be much easier.
There'd also be a question of how the secondary user used it and how much of it, all the questions that come up in fair use. might complicate, well, when is the right of attribution triggered? Is it with Blanche v. Coons, like how much of that photograph, and so when can you demand an attribution right? Could be complicated with remix, whatever.
Creative Commons has an attribution right on almost all their licenses, which
so-
are non-economic.
Yeah, the default used to be no rights reserved, but they found that something like, 97% of people opted for the created by. Yeah, so I guess on that note, I think we have a 10-minute break now. If I'm wrong on that, someone correct me. But 15-minute break, and then we're back in here, I guess, at 3:30.
This has been a presentation of the Library of Congress. Visit us at loc.gov.